Good afternoon, one and all. I, Priya Duggal, on behalf of Professional Development Committee of Institute of Chartered Accountants of India, would like to request the Abhay Charger, Chairman, Professional Development Committee, to please give the welcome address.
Thank you, Priya. Good evening, everyone. So it once again give me immense pleasure to welcome all the distinguished speakers for today's DNA series. We call it as Discover New Avenues Webinar 14. And all the participants who have joined from all across the country, thank you so much, all of you, for joining. And thank you so much, the distinguished speakers, Uday Kulkarni, who's an expert in digital personal data protection. Once that act was there in place, he's been very active at ICI, helping the ICI in publications, sessions, webinars, and also we have started a certificate course on DPDP. Also, he's one of the faculties. So thank you, Uday, so much for being here today and sparing your valuable time. And I'm sure with your experience in this subject, especially which is a new subject for last, I would say, 18 months, this definitely participants would be immensely benefited with your experience. And what we look from the Professional Development Committee is why this Discover New series is just to create professional opportunities in niche areas, new areas for members. So this is one of the initiative which we thought we should start from PDC, and today is the DNA webinar 14th. So thank you, Uday bhai. Also, we have Siddharth Agarwal, who's now also doing very good and becoming an expert in this particular area. And he's also been supporting in webinars and various sectors in DPDP and other areas where he is contributing his immense. So thank you, Siddharth, and being moderator today. You'll be moderating this very important session, navigating compliance and professional opportunities for chartered accountants. So as we all know that a lot of initiative we have already planned from the Professional Development Committee, but this particular initiative we thought is an area where members may not be fully aware. A lot of been heard, but I think what's important is now this act, after it's came in place, enacted, it marks a significant milestone in India's digital governance framework. And when we hear, it is not just any listed companies or large entities. It's for every entity this DPDP is applicable. And I think we must know why it's important, why the personal data protection, digital personal data protection is important, how to maintain that, how to help our clients to maintain this data protection, what system should be in place, what exchange of communication has to be done with the suppliers, with the debtors, creditors, everybody, so that every data is protected well, and whether communication is received on time or not, that's all would be definitely be covered by an experts. And we as chartered accountant are the bridge between the regulators, stakeholders. So it's very important that we keep learning on the new areas and how. And I would say this being the best time when we have the audits now being commenced. Mostly if I talk about large entities, of course these audits are done, but when we talk about entities, small, medium enterprises, or small companies where the audits will be done, or even for the traders, partnership firms, all when they will be done, I think when you'll really come to know what is the relevance of this DPDP Act and how we can advise our client, for the privacy compliance audits, for of course, maybe it may help you in as a risk assessment, and maybe more as evaluation of the internal control, implementation of data governance. So all these, I'm sure, would really help us to create new verticals, new area of opportunity for us. And I'm sure with this faculty, the distinguished faculty which we have, who's been speaking on this subject for a longer period of time, and I'm sure we'll have a lot of valuable insight which they'll give it to us. We'll have practical, the compliance requirement, how practically we have to deal with the implementation challenges, and how the opportunities will then come to chartered accountants. So I encourage every participants to please be there, engage yourself, ask questions, raise questions to the experts. I'm sure they're able to do it in the given time. But if not, then certainly we'll have more sessions in future, which we have planned. Maybe once in a fortnight or once in 10 days, we come up with some new areas. So I once again, thank and express a sincere gratitude to our esteemed speakers and all the participants who have here for this DNA series because of these participants who encourage us to organize such DNA series. So thank you once again, all of you, for joining. And I'm sure we'll have an excellent learning throughout this webinar. Thank you.
Thank you, sir. Now I request Piyush Charger, Vice Chairman, Professional Development Committee, to give the opening remarks for the webinar.
Thank you very much, the Chairman, C. Abhay Chajarji, the domain experts and the speakers for today's session, Uday Kulkarni ji, C. Siddharth Agarwal ji, and all the members, the STA members of the Institute of Chartered Accountants of India who have joined this Saturday afternoon for the next series of DNA, Discover New Avenues. And I know when the topic was chosen by the Chairman, and not only Chairman, in fact, this has been talked in every boardrooms, every office rooms, every office cabins. Now this has been talked, that how you actually comply with this particular act. That's the most important. So it starts with the compliance yourself, number one. Of course, as a chartered accountant, you have always been privy to certain data, maybe as an auditor, maybe as a tax advisors, maybe as a financial consultant. If you have acted anywhere, you were always having an access to certain data, and you know that the client confidentiality of that data was very important. I'm sure you already have those systems in place today also when you are dealing with an audit, and even auditor is required to keep those systems in place. Now the question, of course, it expands beyond. It gives you an opportunity not only to keep your systems in place technically, how you keep the data confidential which you receive in your professional assignments, but it also helps you how you can actually advise your clients that how they control the data, which the data they gather from the various maybe suppliers, various vendors, various individuals whom they are dealing with day in, day out. I'm sure both the learned speakers will help you in understanding that. And once you understand that, obviously the idea of professional development committee is to throw open, to bring out new avenues where each and every member can decide, understand it, and explore which whether they can actually find some professional opportunities on those areas. The question is whether we are able to enable. So this would be, I'm sure it would be a brief discussion in 2 hours, which will give you an idea that if it interests, if it ignites your mind, and if you find interesting, obviously you may have to specialize into that also, which may be at the later stage you decide that yes, I will get further specialized, so it will enable you to provide those services under this particular act. So of course, this is a series of a PDC which Chairman has already explained you. A lot of other areas of the expertise where the chartered accountants can look forward to. We'll also try to bring out through this weekly seminars. And as I wish you a best for the next 2 hours, have a very good evening discussing with the 2 domain experts, Udayji and Siddharthji. Thank you so much. Over to you. Priya, you can take it.
Thank you, sir. Now I request CA Uday Kulkarni, sir, to please start with the first technical session.
I hope my presentation is visible. Yeah. So first of all, I would like to thank Chairman Sir Abhay Chajarji, Vice Chairman Sir Piyush and Priyaji for giving me this opportunity to talk on this hot topic, as Piyush has rightly said, that is now getting discussed in every boardroom. I can still remember we started this series as a webinar under the leadership of Abhay Chajarji when he was a chairman under the Commercial Law Committee. And even when the law was in the draft stage, he encouraged us to take a couple of webinars so that the chartered accountants can understand the provisions of this law and they can prepare themselves to gather or catch the opportunities which are under this act, because it's having the larger and greater impact on every business organization, service organization, through which the chartered accountants are providing these services. Also, I would like to thank the PDC also, because they have coming up with this kind of a series which is going to provide lots of avenues, new avenues, I can say, from the traditional areas to the new areas, and that will be definitely going to be certainly helpful for the chartered accountants. So thanks all of you for this opportunity. Coming back to our technical topic, so there are two parts of this webinar. In the first part, I'm going to take you through this act, the importance of this act, the provisions, some of the important provisions of this act. And of course, then my colleague Siddharth will take you through the opportunities and some of the challenges or how the chartered accountants can gap these opportunities at their client place or for their own office purposes. So let us start discussing the provisions of this act. So if you see the act, this is what we are going to discuss today. This is what is on our plate. But I know that all of this I'm not going to cover. Some part of that is definitely going to be covered by the Siddharth. But first, let me tell you that when we are now very much active on the digital platforms, right now also you are on one of the digital platforms, Zoom. So if you see of our office work as a chartered accountant, we are very much there on the digital platforms, whether it could be on the taxation related platforms, accounting related platforms. So the digital transformation has changed the working style, the processes, everything in our CS office. And this is not limited to the CS office, that has been there for all other business entities as well. So if you can see, most of the staff of the business organizations or the service providers, including ourselves, we are spending a lot of time on the digital platforms. And when it comes to the digital platforms, no platforms is giving you the free access without having your some personal data with them. So wherever you want to go for your Gmail, where you want to go for your any other platform, they want to know you, right? So they are catching your personal name, they are gathering your date of birth, your mobile number, alternative email, and so on and so forth. But we need the services from that particular website, from that particular portal, from that particular web platform, and we don't hesitate to provide this data to them. And at that time also, we do not have a second thought about. So whenever, if I want to go to the ChatGPT, if I want to go to the Claude AI or any other AI platform, what they are asking about, they are providing us whatever the AI related services. But before providing them the services, even we are using it for the free purposes, we have to make a login into that. So we have to provide some details, and then they will provide the login credentials to us. And whenever the next time you find that you want again the services from the ChatGPT, you just click on that portal of the ChatGPT, and again you don't have to provide your personal details, or you don't have to sign in there. And you must have experienced that whenever you are connected with such a platforms, they are recognizing your devices also. Right. So if you are connecting to ChatGPT from the laptop, the ChatGPT recognize that this particular devices is belong to this person, and they are continuing with your login credential. But the moment you change the device, right, and you try to get the services of the ChatGPT, then there may be the different scenario. So what is this is happening? So please understand that they are not just picking up your personal details like the name or the date of birth or your email IDs and all that, but they are also recognizing your IP addresses. They are also recognizing your device details, and by that way, they are identifying you. So what I want to tell you, the identification norms in the digital platforms are really changing. It is not necessary to change it is not necessary only to tell the name and the date of birth, etc., etc. But even our devices, their MAC IDs, our digital personal data. And now you must have heard the discussion is going on because the WhatsApp is coming up with the kind of a feature where they are telling that now instead of mobile number, they are going to include the particular name, login name, and with that login name, the user will be identified. And a lot of discussions are going on. Central government has issued the notice to this Meta and all these things, that there could be the security concerns when they are going to use this kind of features instead of the mobile numbers. And if you see some of the regulatory guidelines related to telecom authorities, now they are also pushing up that without the SIM, you cannot provide certain types of the social media platforms to the users in India. So even SIM card, the SIM related numbers, technical numbers, all those are going to be identifiable personal data. And why I'm saying so? Because you can see that at how many places, if I ask you that how many places you have placed your name, your email, your date of birth, and your mobile number, you don't have any count. Frankly speaking, we don't have any count. Even I myself don't have any count that at how many digital platforms I have shared my mobile numbers, I have shared my email addresses, I have shared my date of birth and name and addresses. Because that is the necessity, that is the way of life, that is the way we want to perform our functions. And these digital platforms, we don't understand. Now, if I say to you, or if I ask to you, when you are taking the services of any free email services, it could be the Gmail, it could be the Rediff mail, it could be the Yahoo, whatever it could be. Do we know that where our data is getting stored? Where that login credentials are getting stored? Where is that server? In which cloud? In which country? Whether it is in India, whether it is outside India, and how that is going to be controlled by the security point of view, right? So all these questions we never bothered about, but now considering the misuse because of the artificial intelligence has become a new tool for the fraudsters or the hackers to do a lot of unwanted things on the digital platforms. So all this data has now got a lot of values. पहले क्या था when I literally say this that in India there is no need for the protection of the data. Why I'm saying so? Because even we travel in the train or in the public bus or the public train, what happens that we share all our personal details to the co-passenger. We really don't know him that who is traveling with us. But क्या हो जाता है हम हमारी सारा खानदान की हिस्ट्री हम उसको बोल देते हैं. So that is the way we Indian are living still now. But that was the person to person kind of a relationship. So we have that kind of a trust on those persons. And that's why there is no hesitation on our part. Because what is the trust? What was there? The trust was that even I'm telling that to the co-passenger, which is very unknown to me, we are having the trust that he's not going to misuse that. That trust of utility, that trust of using up the data, that is what is quite important. But now the same trust, when we are providing the data on the digital platforms, whether we are sure that whatever the data we are providing to these digital platforms, like the co-passengers, whether they are going to keep it secret, confidential, and they are not going to misuse that. So that trust somewhere is missing, right? And that is the reason most of the countries, not most of the countries, I can tell you that 140 plus countries in the world, they have adopted this Digital Personal Data Protection Act in one way or another way. Provisions more or the less are the similar what the India model has adopted, but the provisions are there, and every country has recognized that the privacy is the first fundamental right. In India also, that has been accepted under the constitutional personal fundamental right. And under the privacy, the digital personal data protection is one of the privacy related right, which needs to be guaranteed, secured by the government. And that is the purpose for bringing this act in the place. So the basic purpose of this enactment of this act, that whatever be the data which is provided on the various digital platforms, whether it is for the generic purposes, whether it is for the banking purposes, insurance purposes, shopping purposes, wherever we are providing the data, there must be the regulations, there must be some provisions, and all these digital platforms or the service providers, whoever is collecting all such data through the digital modem, digital domain, they have to use this data as per the provisions under this act. So that is the background with which this act was enacted. And when we talk about because this act largely it is going to impact all those tech companies who are providing lots of digital services, digital platforms, and who are not providing those kind of services. Even the chartered accountants are now providing the services through the digital platforms. So all of those service providers who are providing the services through the digital platforms, even the shopkeepers, they are also providing some of the services on the digital platforms. So all of them, they have to now make an compliance, ensure the compliances about whatever the provisions are here under this act. And there, as I said, if you see, it is not limited to any one sector. Of course, there are certain exemptions for certain sectors like the education, schools, and so on. But apart from that, mostly if you can see, the act is applicable almost to all the sectors. And these sectors are very much near and dear to the CS profession, because CA profession are already providing some services to them. One more impact you might have been noticed or experienced if you are working as a concurrent auditor of a bank or a statutory auditor of a bank. You might have experienced that when now you are going for the concurrent audit, statutory audit of the bank, they are now hesitating to allow you whatever the data you are collecting from their computer. What they are saying, now whatever the data processing, whatever the analysis, whatever be the verification you need to carry, you carry that in their own digital environment. They are not allowing to share those details outside their environment. That is the greater impact most of the chartered accountants have experienced, because a lot of queries has come from the chartered accountants that how to handle this situation and how to make a compliances with our auditing standards, working papers management. So all these questions are there. Of course, this is a good discussion, and good queries are coming out of this. And what we have to consider now, even chartered accountants on both ways. As a chartered accountant, we have to implement the provisions in our offices. Our certain practices, our certain procedures for providing the services to the clients through the digital mode, that needs to be redesigned. And on the other way, while redefining our services, we should also understand the same thing is going to happen at our client base. So whatever we are going to do in our office, that is going to happen at the client place, and we should be able to provide the same services in a various capacity, with the Siddharth is going to talk about that in another couple of minutes. Let me tell you that this is a law which requires the compliance, but compliance not on the paper, the compliance on the technology. So that's why I call this as a techno-legal law, right? What is the meaning of the techno-legal law? So it is a law. Law needs to be ensured. Law needs to be complied with. But for the sake of the compliances, there are certain mechanisms, there are certain tools, there are certain technologies that also needs to be installed, invested into, or some of the sector, technical sector related services needs to be availed for. So it is not only the legal compliance, it comes with the technology. So understanding of the technology, your understanding of the DISA, CISA kind of a knowledge, your understanding about the digital process flow, your understanding about the data flow, your understanding about the technological network flow, all this is going to be helpful. And again, I'm saying that we are very much ahead than the others, because the chartered accountants is having the upper hand in understanding the business process and the business context. So at which business processes this data, personal data is captured, how it is processed, how it is used, how that can be minimized, right? And how that can be controlled with the technological tools, that all can be well understood, well explained by the chartered accountants. And that's why I personally feel that there is a lot of scope for the engagement for the chartered accountants. Of course, I'm not going to deal with that. My colleague will going to tell you about that. Now, coming back to the provisions of this act, as I said, we need to understand before we need to start the implementation and talk about the ensure compliances under this act. We need to understand some of the important concepts under this act. So what is digital personal data? What is personal data? All that we are going to talk about. That understanding of that concept is very much important. But under this act, what is mandatorily be stated? Again, that is a punchline of this act, that whatever be the digital personal data which is captured, that needs to be used for the lawful processing. That is the very basic essence of this act. So whatever be the purposes for which a data is going to be gathered. So why the chartered accountant is gathering the data? Chartered accountant is collecting the name, but date of birth, PAN, Aadhaar number, right, mobile number. This is the personal data. Why the chartered accountant is collecting all this data from his client? For filing of the return, for the GST purposes, for the audit purposes. Whether these are the lawful purposes, yeah, of course, these are the lawful processing purposes. Other businesses also, whenever they are collecting the data, they have to set the purposes. Why I'm collecting the name? Why I'm collecting the mobile number? What is the purpose of that? And whether that purpose is a lawful or unlawful. If it is a lawful, then the data processing is allowed. But I'm capturing the data for the income tax filing return, but I'm sharing that data with somebody else without the consent of my client, then that will be treated as an unlawful processing of the data, right? So lawful processing, what is the meaning of that? So lawful processing, the definition is one way. Practically, we need to understand the data. What are the different aspects or the facets of the data we are collecting? Why? We should have the inventory first, that which data we are going to collect. We are personal data I'm talking about. So we are going to collect the name, addresses, date of birth, the PAN number, Aadhaar number, why it is required. So purposes in front of that inventory. So this is the purpose, this is the use, and I'm going to use only for these purposes, not beyond that purposes. That is actually the lawful processing under the provisions of this act. Now, whether I can freely use the data without noticing to the customer, the answer is not. The answer is no. Because the act itself has given under section 5, sections are not important, so I'm not going to mention any sections for the sake of understanding purposes. So law says that before lawful processing, you need to intimate to the client that we are going to collect this much of the data and we are going to use that for so many purposes. That notice should be given to every client, and that is for every sector, not only for chartered. I'm not talking only for the chartered accountant. Of course, it is for the chartered accountant, but along with that, for all other sectors, whether it is IT sector, whether it is pharma sector, whether it is hotel sector, or whatever be the sector. Even those digital platforms who are collecting the data on the digital platform mode for the login credentials or other purposes, they have to clearly display the digital notice for what purposes they are going to collect the data and what is the purpose of that. You might have seen that many of the times when you are logging, when you are connecting with the website, they first display that accept all cookies, not accept all cookies, manage the cookies, all these things you might, and blindly, most of the times a layman blindly click on accept all the cookies, because he says that if I deny to accept all the cookies, there could be the services which might be hampered. Of course, it might hamper, no doubt about that, because some of the services then that particular web portal will not provide to you, because for that providing the services, he may require certain details. But now only accept all cookies, manage all cookies, that kind of a notice in India mein nahi chalega. That could have been the provisions under other countries. And if somebody wants to know what are the conditions under that cookies, then he have to click additional terms and condition, and then he will understand that. But India, यहाँ की situation ये है, the layman does not understand what is cookies, what is the use of the cookies, how that is related to the digital personal data. So ये सब पता नहीं है, बहुत सारे chartered accountants को भी ये पता नहीं है. So the first thing is that we should aware about how the consent is actually given. And before giving the consent, notice is important. So India, if Indian website or any other country's website, which is now going to collect the data of Indian citizen, it should not only set the cookies, but it should set what data they are gathering and what is the purpose of that. And then there would be the accept all or deny kind of things, right? Otherwise, it is not the compliances. And see who can advise them, who can tell them all these things, who can see whether they have done or not, audit, monitoring, all these things, lots of opportunities, right? Isn't it? Then, so notice is important. You cannot manage the notice on the paper-based say. So many of the businesses, they are talking to me that, okay, we can manage the notice by taking the printouts and we'll collect. No, it's not a like notice requirement, because along with the notice, there is a consent requirement. And notice because language में because India there are lots and languages are spoken or talked. So it should be the language which is understandable to your customer. Again, that is very much essential for the notice purposes. Once the notice is issued, then a specific consent should be obtained from each and every client, whether the client is existing one, purana ho, naya ho, aane wala ho, right? For all these existing as well as the prospective client, you need to take the consent, and before taking the consent, you have to send the notice, whether it is by the mechanism. For that purposes, as I said, certain tools are very much required. You cannot manage that with the paper-based working, right? And for every purposes, whatever the data you are collecting, for every purposes, the consent needs to be obtained. Now here is the important interplay will arrive. Now let us say that I'm chartered accountant. I'm providing particular services to X to file only the income tax return. So when I'm providing that services, what would be the data which is required for the income tax return filing? I will catch that, right? And I will see that in the notice that purposes, I will mention that, okay, this is for income tax purpose, this is for income tax, and so and so on. The moment the client will ask us, okay, now you also file my GST returns. Along with the income tax return, you also handle my GST things. Now, what is happening? The consent, for what purposes we have obtained the consent? We have obtained the consent only for the income tax purposes, but you are not obtained the consent for the GST purposes. So again, you need to reissue the notice. He has to give you the reconsent for that purpose. It may also happen that some of the client, they may, at the initial stages, they may provide you the consent for both the things. Okay, this you handle this income tax return, you handle this GST return. Subsequently, they will say, no, now you discontinue the services of our GST, you only handle the income tax return. So all these records, the track, the usage, that needs to be provided to the user, to our client, and that is the right which has been given under this act. So like a bank statement where you will find the debits and credits, right? बैंक के अकाउंट में क्या हो जाता है? Debits और credits. हमने पैसा कब डाला, हमने पैसा कब निकाला. Similar way, a record needs to be kept in that manner. नोटिस कब भेजी, यूज क्या किया, कंसेंट किसकी दी, कंसेंट वाइज उसका यूज हुआ, कंसेंट कब विड्रॉ की. सो ऑल दिस ट्रेल नीड्स टू बी कैप्चर्ड in a particular ledger, and that's what I said, it is not possible through the paper working. It requires a technology, right? So this is a complete cycle for the notice and consent. Now legitimate uses, as I said, where it could be an emergency. Always there is not possible to give the notice and take the consent. Like there is an emergency, there is a road accident. आप वहाँ ऐसे नहीं बोल सकते कि इसका कंसेंट ले लो, इसको नोटिस भेजो. सो इट इज अ स्टेट ऑफ इमरजेंसी. कोई अर्थक्वेक आ रहा है, कोई नेचुरल डिजास्टर आ रहा है. सो there nobody is going to take the notice and the consent number. So this kind of an usage have been exempted. So some of these kind of an usages have been exempted from the compliance point of view for the purpose of these things, right? Then there are certain obligations on the data fiduciary, and there is a lot of talk. That's why this act is in more talk, because of the heavy penalties are enacted under this act. It comes from 250 crores and all that, right? Now, the next thing we need to understand, because we are talking here about the digital personal data, right? So what is that digital personal data? Many of us may not be aware about that. What is digital personal data? For understanding the digital personal data, we must understand what is personal data. So personal data, the whatever be the you can say the data by which the individual can be identifiable. So how can we identifiable? Basic thing is the name, our nickname, that is also possible, right? Then by our mobile number, by our addresses, by our email addresses, isn't it? By our date of birth, by our biometric, right? So this is normally known to us as a personal data, because this personal data we are visualizing in an environment where there is no digital technologies involved. So when I'm talking person to person while traveling, there is no digital medium in existence. So it is a person to person talk, but still we are sharing the personal data. Whether that becomes the digital personal data, answer is no. Why? Because their medium is not digital. The moment that personal data is getting exchanged through the digital medium, then it becomes the digital personal data. What is the meaning of that? So when you go to the bank, you give them a form which is on the paper, that is not on the digital way, which is on the paper, and on the paper you mention your name and all your personal details. That becomes your personal data. But whether that becomes the digital personal data at that time when you are filling that form, the answer is no. But the moment you hand over it by signing on that particular form, you hand over it to the bank staff. What the bank staff does, bank staff enters that entire data into the CBS systems, right? So when they are entering all that data into the CBS systems, now it is getting the flavor of the digital personal data. Personal data at the paper mode, it is not a digital personal data. It is a personal data, of course, but that is not a digital personal data. The moment you enter that data on any digital platform, whether it is CBS, whether it is your taxation tool, whether it is your accounting tool, whether it is your GST tool, whatever it could be. So the moment you are transforming that from the paper-based data to the digital medium, it becomes a digital personal data. And from that onwards, the journey of the provisions under this act starts, right? And apart from now, when we are talking about the personal data, when we are talking person to person, there are limitations. But when we are talking about the digital personal data, additional certain features of the data are getting included as an identifiable features of that particular person. Number one, IP addresses. Number two, device related details. Number three, the search history. Number four, likes and dislikes. So this is easily captured by any the digital platform. So whenever you search for a particular travel plan or from particular flights on your browser, then you see that next time when you go again for the browsing, you see the lot of advertisement related to that particular flights. Why this is happening? So somebody, your history is getting memorized, and of course we all know that history is there, and that history analyzes your likes and dislikes. So somebody behind that, it may not be the by some person, but through some engine, through analytical engines, through the AI based technology, somebody is analyzing all your activities on the digital platforms, and that is happening. No one can deny that, right? And that is also going to happen a digital personal data. So every time through the Swiggy, if you are ordering a pizza, a particular type of the pizza. So the moment now you enter into that particular website, it will automatically start showing you your likes, that this is your pizza which you are frequently ordering. That means what? So somebody is analyzing, somebody is keeping watch, and it is tempting you to order the next things. So that also becomes your digital personal data. Now, so many things without having the awareness, because right now we are talking as a chartered accountants, but you can think about 150 crores in India. Uh, how many of them are aware that this kind of tracking, this kind of things? Because almost everyone in India is now having the mobile phones. So all their IP addresses, all their device related details, all of them are getting spread across whatever the website they are visiting into. And they are not aware that this is also my personal data. They are not totally aware about that. So you can see how many work is there to make an awareness, to make them, because this is a part of, again, a cybersecurity. If you see the larger requirement of all these things to protect, why it is essential, because of the misuse. Personal data sharing, there is a conditional misuse, or there may not be any possibility of misuse, but on the digital platform, we don't know where the data is stored, who is getting access to that. When I'm sharing my status on the WhatsApp status, right? When I'm sharing my photos on various social medias, how many of us know that where it is going to be? When we say, okay, I'm uploading that as a status, okay, fine, it will disappear within 24 hours, that is fine. But what the layman thinks that, okay, after 24 hours, that means that data has gone, everything is deleted. But whether it is actually getting deleted or whether it is getting still stored somewhere in some server, and that is not within India, that is outside India. So the hackers, crackers, the fraudsters outside India can make any misuse of that particular photos or the status, whatever we have kept. What is the control on that? No control. And that's why the government thought that, like the physical security is the responsibility of every country, the digital security, the digital personal security is also the responsibility of the every country. बिकॉज मेरे सिटीजन, मेरे कंट्री के जो सिटीजन्स है, उसका डेटा अगर मेरे कंट्री के बाहर जा रहा है और उस पर मेरा कुछ भी कंट्रोल नहीं है, सो दैट अदर कंट्रीज fraudsters can misuse my country's data, how that is going to be affecting the whole world. Everybody has that concern. And in India, that kind of a literacy is still not there. That's why even the understanding of the digital personal data, we may require a separate session. So that is again one of the important concepts that has been defined, and it don't think that it is only the name and date of birth is your personal data. The canvas is very large, right? So please understand that. Then comes into the picture the data fiduciary. The data fiduciary, that means who is collecting the data. So chartered accountant is collecting the data for providing the services. So chartered accountant becomes the data fiduciary. Hospital is collecting the data from the patient. Hospital becomes the data fiduciary. Bank is collecting the data for the banking services. Bank becomes the data fiduciary. So actually, who is collecting that data for certain purposes, that person becomes a data fiduciary. Then what is the concept about the person of whom the data is collected? That person is called as a data principal. So hum sab 150 crore plus people in this country are going to be a data principal. Exactly, if you want to tell you like that. So everybody in this country are going to be a data principal whose data is going to be processed on the digital platforms. All those persons becomes a data principal. The moment you are connected with any website without giving your any personal details like the name, etc., the moment you are getting connected with any website, if that website captures the IPs and all other details through the cookie settings, at that time you become the data principal. So even without providing certain details, you are getting the rule as avatar as a data principal. And of course, that is a good cause that has been recognized because certain fundamental rights have been given to the data principals. The next stage is data processor. What happens? All the data may not be handled by the data fiduciary himself. So the chartered accountants collecting the data, but he is obtaining for the taxation purpose, accounting purpose, GST purposes, all right, the services which he is providing. But where he is placing the data, all the data he might not be able to process through that, the taxation related tool or the accounting related software or the GST related software. So he might be availing the services from the cloud. So he might be having the accounting software that is based in some cloud. He is availing the software platforms, let us say for the income tax purposes of the taxation software, and that is a cloud-based software. So what is happening? You are sharing the data because you have to enter that data into that software for the accounting purpose, for the taxation purpose. So that cloud becomes your data process. Similarly, in the banks, let us say we demand for the debit card or ATM card. Whether the card is printed by the bank, the answer is no. So card is printed by some third party. It is not by the bank. But for printing of the card, for making available you the card facility, bank shares your data to that third party card vendor. So that card vendor becomes the data processor. Some of the companies outsource their payroll function to some of the chartered accountants or other companies as outside entities as a third-party service providers. So they there becomes the data processor. So original data is captured by the data fiduciary, but the data is going to be processed by the third-party service providers, and they are going to call them as a data processor. And there must be certain obligations on both of them. There are obligations on the data fiduciary. There are going to be obligation on the data processor. In case of chartered accountants who are doing a statutory audit, their role, of course, some debate is going on how to treat that, and of course, the ICAI, PDC, and all other committees may come together to recognize that at least the statutory auditor is the legal services, and that can be exempted for this kind of compliances. But that is another issue. But at the present, if we are doing the internal audit of any organization, so we are not collecting the data. The data is collected by our clients. So that becomes the data fiduciary. We are processing the data for our internal audit purposes. So our role that is getting exchange there as a data process. Now, as I said in the earlier slide, that there are certain requirements to send the notice, to obtain the consent. Then the client does have to make a lot of modification, changes, withdrawals, again giving the consent. All these things are going to happen like the debits and credits in the banks. So all these things are going to be managed by the consent manager. So that is a new entity which is rising up because of these provisions of the Act. And I feel that this is a techno-savvy company. This is a tool-based company. And consent management does not only means use of a certain software, and that's why we say that we have managed the consent. It's not like that because the consent manager needs to be approved by the Data Protection Board of India. So it is the DPB, Data Protection Board of India, who will publish the list of the approved consent manager, and their services we may have to avail for that purpose. Some of the large entities like the IT companies, like the social media platforms, the Google type the platforms, vast email service providers, all and banks, insurance, the stockbrokers, they are handling the enormous amount of digital personal data. So those entities may be declared, not yet declared, but that may be declared as a significant data fiduciary because on the basis of value, because of the sensitivity of what the data they are handling and all these things. So they may be declared as a significant data fiduciary, and they will have to ensure some of the additional compliances rather than normal data fiduciary. And there again, we have a lots of opportunity. What is the offense under this act? Because we are talking about the penalties, we are talking about the compliances, but what will be the offense under this act? So offense is in one way that is defined. It is a personal data breach. That could be the offense. And this concept is everybody needs to clearly understand what is personal data breach. The first thing it is defined under this personal data breach is unauthorized processing. See, every word, every terminology in this is very important. Unauthorized processing. What is unauthorized processing? So without notice, without consent, I can't process any digital personal data. Are you understanding this? So the moment a client is coming to me and saying that file my income tax return, I directly cannot file the return. Because before filing up the returns, I need to complete this procedure, that notice and the consent with a trail. So in case of a dispute, I should have a concrete evidences with me. If I'm not doing that, and without sending the notice, without obtaining the consent, if I'm processing the data, that becomes a personal data breach as an offense. Second thing is that consent has been given for the income tax purposes, but I'm processing it for the GST purposes without obtaining the consent. That also may qualify as an unauthorized processing. And that's why you can understand now what is the purpose, what is the use, and what is the notice, what is the consent. All these things needs to be interrelated, right? So that one thing we need to understand. Then a disclosure requirement. unauthorized processing, unauthorized disclosure. So without the consent, if I disclose the data to any third party, without the consent, I've sent that data to third party data processing. So whenever I am capturing the data, if I'm using the cloud-based tools, I need to mention in the notice that your data is going to share with these cloud-based tool platforms. Without sending that notice, if I process that data, that becomes unauthorized disclosure. Sharing, acquisition. Sharing, what is mean? Sharing means that I have captured the data. I obtained that with the legitimate purposes, but now I'm sharing that to my other business purposes to somebody else. Let us say for the marketing channels, right? So that some publishers comes to us and say that, okay, this is your data we are having. Now share your friends' data. So where we can go and visit them and tell them about our publication. Okay, if it is person to person, that will have the different aspect. But when we are sharing our clients' data to them as a publication provider, then that becomes a breach of the personal data, right? Any use, alteration, even the alteration without the consent. We know that there is some spelling mistake, there is some address related changes that might have been taken. Even the destruction, loss, all these things, if we do without the consent and the notice, that qualifies as an unauthorized processing. And when you go to talk about actually the offense, even the accidental disclosure of the data is treated as a personal data breach. What is an accidental data breach? So let us say we are having the habits that we share the data to our staff, to our articles, to the paid staff. By what mode? By digital mode. So let us say for filing of the income tax return, we are sharing our data to my staff with, let us say, on his personal email or through the USB pen drive. That could be the way by which I'm sharing the data to my staff. Staff is processing that data on their computers, on their own computer. It is not a staff, it is not the office computer, but it is their own individual computers. Now what happened? There is no intention of the staff. There is no intention of the chartered accountant to disclose the data to any third party. But what happens? That email of that particular staff is hacked. The USB with which we have given that data to that particular staff, that has been fallen down accidentally, and through that data breach has happened. So that is going to be a personal data breach. Even accidental disclosure is not allowed. And that's why in the beginning I have said that we need to redesign all the processes considering all these things. And there the technology is also required. As I said, principals, the individuals of whose data it is going to be processed, that has given lots of rights. These are the legal rights. So what is the first right that has been given? The right to access the information. What is the right to access the information? So the user, our client, or every client of every sector, that client has a now right to ask how my data is used. Show me the statement. And that's what I have said in the beginning. I have given you the consent for these purposes. For other than that, where you have used my data, show me the statement, show me the trail, show me or give me all the details. That right has been given to the data principal. Second right has been given, right to correction and erasure. So if there is a spelling mistake, if there is any change, if there is any modification, if that is going to happen, then they have a right to come to you and ask them to modify the data according to their modification. Also, once the service purpose is over, then they can ask you to erase the data. So let us say that they have come to me to file the income tax return, GST return, and now they are saying that, okay, now we have stopped our businesses. There is no need to file income tax return. There is no need to file the GST return. So now whatever the services you are providing to me that we are not going to avail, or any of the services, either of the income tax or the GST, we are not going to avail from you. So whatever the data related to that, erase that personal data. That demand could be there. That right has been given to the data principals, right? Of course, the data fiduciary, they have to think about what are the provisions under the other laws. Because in case of banks, if you see, they can come to us, they can go to the bank and say that now I'm closing my all accounts, please erase the data. Yes, they can demand so. They have the right. Bank must say them, yes, we will erase your data subject to compliance of other laws. So there are Bankers Books Evidence Act, there are PMLA Act, which requires to keep the data for 5 years, 8 years, and 10 years. So to ensure the compliance of these laws is also there. So they will say that, okay, we'll keep your data separately by the technological, you can say segregations, and that your data is not easily accessible, but it will be not erased right now. But after the compliance of other laws, it will be definitely get erased. So that, but if it is required for the investigation and all these things, all that possibilities is also be well taken into consideration. Right to grievance redressal. So there must be one mechanism. So every data fiduciary, there must be you can say a link given to our customers. Either it could be the link through the website, the phone, or the emails, a mechanism by which our customer can file the complaint about the misuse or unauthorized use of any personal data. Interesting right has been given the right to nominate. We have seen this terminology in the banking sector or in the insurance sector, where after the death, to whom the funds could be transferred to. Similarly, what should take place in case the my personal data is going to handle after my death? Who is going to decide that? Right. So after the death of any individual, how to deal with that individual's data? That purposes, the principal can appoint a nominee, and that nominee will take or decide the course of action, how to handle the data of a dead person. Right? Then there are certain duties also of the data principal. They have to give the correct data, not to impersonate, and all these things. Some of the duties are also posted upon them. What are the obligations of the data fiduciary, which is there, which is required to be ensure the compliances for? Any tech support or anyone here from the PDC? Is there someone?
Yes.
So I think I can extend it for 5 to 10 minutes more.
Yes, sir. No issue, sir.
Okay, fine. Thank you. So there are certain obligations, certain things needs to be ensured by the data fiduciary. So first thing, the accountability for the lawful processing. Otherwise, that will be the data breach. I can call not only the data breach, it is a data diversion. Like the funds diversion, it could be the data diversion. What happens in the fund diversion? We take a loan for a particular purposes, and the loan amount is used for any other purposes. I have taken a loan for the construction of the factory building, but I use that particular loan amount for construction of my house. That is the first diversion. Similarly, I have taken a consent for the income tax purpose, but I use for any other purposes. That could become a data diversion, and a lot of complaints may arise, not related to chartered accountants, but you can think about the other sectors where that kind of complaints would be there. Then if I'm going to outsource or I'm going to share that data, as I said, with a third party as a cloud service provider or any other third party vendor, then there must be the valid contract between the data fiduciary and the processor. That means a chartered accountant should have a valid contract between the cloud service providers providing the taxation tool, accounting tool. And in that, why that contract is important? Because in that, the obligation to protect the personal data of shared data of my client should be protected by that process. That clause is very much important. Then, of course, the data accuracy. So if I'm sharing the data with my processor, it is my responsibility to share that data accurately. He is not responsible for the completeness and accuracy. See, if I'm providing the wrong, pay scale slab for the payroll processing company, it is the fault of the data fiduciary. It is not the fault of that particular process. So data accuracy, providing all the personal details very accurately to the third party processor. and maintaining that data accuracy and completely. I cannot just hand it over few of my data field and not all the data field. I cannot do that to have the completeness of the data. So data accuracy with the completeness, accuracy, and consistency kind of a feature is the responsibility of the data fiduciary. Then technological and organizational measures, as I said, it is not only the legal compliances, but it comes with the techno kind of a tool. So I need to protect the digital personal data. I need to secure the digital personal data. For that, I need to involve the tool for the inventory identification, personal data inventory identification, then masking of that, data minimization related tools, encryption related tools, anonymization related tools. So all these are the technical measures that will give a security and the protection, and that is what is the core part of this data, and that is what is the core obligation of this data fiduciary. So how I'm protecting the data, technically how I'm protecting the data on the digital platforms, right? So that technological things, ensuring the technological things, ensuring that the technology is foolproof, secure, with the CIA kind of things, confidentiality, integrity, and availability and accuracy. All these things needs to be ensured through the technical measures. And there, what I say that we must possess, if we are providing some services to our client, we should have a lots of opportunity. If you can have done the DISA or CISA kind of things, because you can understand there the data flow, the where that has been used and all this stuff, right? Reasonable security safeguards, that is with the help, as I said, with the technology. Without that, we cannot do that. And the breach notification. Despite all these things, it may happen that some of the data may get leaked because of certain ransomware attack, or because the cyber threats, the AI related tools that has been used for breaking the security. So it may still possible that the data leakage may happen. But when such data leakage will happen, it is the responsibility of the data fiduciary that this has been happened, and that needs to be notified to all the customers, to the Data Protection Board of the India, and there are certain timelines within which that needs to be given. And not only we have to notify, we need to identify the impact. We need to do the impact analysis of all these things, right? So that is also there. Then, as I said, when there will be call for the data eraser, the first thing they have to ensure that there are certain timelines where the law requires to keep that particular data. As specifically for the children's or the person with certain disabilities, the consent is required from the parents. So parental consent is one more aspect in the notice and consent management. And when they are attain the age of the measure, then again there will be shift from that. Certain services, if you can see, which we avail, like we are availing the services of aggregators like the Ola, Uber, or some of the shopping, shopping websites or web platforms. There, we might have visited once or twice. We might have used that services once or twice. But thereafter, we are not going to use that services. So in that case, there are certain obligation of the data erasing, which is provided under the Rule 8 of this Act. So technicalities are not so. Zomato user has closed the account, then the food order must be erased. And for that purposes, certain timelines has been given under this particular activity. Then grievances mechanism, as I said, there must be a link, a phone call, or the email that needs to be there to address the concerns of our customers. And in case of a significant data fiduciary, there must be complete and mandatory appointment of the DPO. So in case of a significant data fiduciary, certain additional obligations are there. What are those additional obligations? So they have to appoint, as I said, DPO, Data Protection Officer. Then they have to carry out every year the data audit. So independent data auditor is required. Then they have also ensure the compliances of rights given to the data principal, USCA audit, the due diligence of the algorithmic software which they have used, then the data impact assessment that needs to be carried out by them. So these are the additional obligations which are there for the significant data fiduciary. As I said, who could be the significant data fiduciary? Who is handling the large volume and sensitive personal data? So basically all those social media platforms, the tech companies, the websites, the portals, the banks, the insurance companies, all those will be fall under the criteria of the significant data fiduciary. And there is a huge number of sectorial presence of this significant data fiduciary across all the sectors in India in economy. And that's what I said. There are multiple opportunities for the chartered accountants to get their need under this. Right. So like there are obligations for the data fiduciary, there are also obligations on the part of the data processor. Right. So as I said, there must be valid contract between the data fiduciary and the data processor. So if we are taking the services from the cloud platform, we should have the valid contract with them. They also have the security safeguard, like technological security safeguard, who the data processor, whatever the responsibility on the data fiduciary, the same kind of security safeguards they must have. And the data fiduciary, they have to ensure that the security safeguards are there. And for that purpose, a third party audit that is must. Like you might have heard about the SOC kind of an requirement under the AICPA. So similar kind of requirements are also there under the auditing standards of the India. And you must be happy to know that the first time in the world, our ICI has brought the data protection audit related standards. Right, this is the first time in the world. So these tools are very much helpful for you to understand how to do the audit at any sectoral places at any data processor level. Then when the services are terminated, the eraser kind of a requirement must be there in your valid contract. But after all, even we are entering into the valid contract, we are putting up all these clauses in the contract. Still, the obligations of maintaining the confidentiality and the protection of this digital personal data still lies with the data fiduciary, right? And again, if the data breach happens at the data processor level, it is the responsibility given to the data fiduciary to report such breaches, right? So that mechanism needs to be also understandable. These are the implementation guidelines. So time is running fast. Now less than a year is there within our hand to implement, to provide the services to our clients. Because as Piyush has rightly said, in every boardroom, there is a talk about to achieve these timelines up to the 30th May of 2027, by which every organization may be ready technologically to ensure compliances of all these things, right? So data protection board, that is under the setup, still not as set up, but government is under the process of setting up data protection board of India. We may see within a month or two that the functionality of this data protection board of India that may become alive, right? So we are also sharing data to various government authorities. There are certain exemptions for certain compliances are given for this purposes to the government sector. Similarly, there is one interesting exemption which is given under Section 7A, that in case the data, personal data is voluntarily given to any organization, of course, they have to utilize that for the legal processes, legal purposes, but certain exemptions for certain compliances are given. And what could be the situations? So let us say we are going to the pharmacy shop and over the counter we are purchasing some of the medicine. There it is on our wish whether to provide the personal data or not. So we are this some examples I have given here. So real estate inquiry in case of an hotel check-in. So some of the things where we are providing the data on our voluntary basis. So there may need not be the whole cycle of the compliance will be required. But of course, the legitimate use, the processing of that for only legal purposes, that is mandatory. And there are certain tests how to consider that whether this is a voluntary submission or not. So the tests are there, whether the choice is available. So whether it is mandatory to disclose the personal data or it is not mandatory. If there is a choice, we can say no. then it is a voluntary submission. Purpose, when we are submitting the data, purpose is clearly known to us. So when we are providing the data over the counter to the pharmaceutical shopper, so he said this is required for the billing purposes, then that is only the purpose. He cannot still share that data with the marketing guys, right? So purpose is clearly stated, and the data principal does not have any objection while sharing such kind of an data. So these are certain exemptions which are considered under the provisions of this act. Now, next onwards, the operational challenge, opportunities, and all this stuff, I think Siddharth is going to handle about that. So I would like to stop over this slide here. I think I have consumed already 11 minutes of Siddharth. I hope any questions that will be taken at the end of the session. So Siddharth, you can now take it
Sir,
ahead.
thank you so much, sir, for your
Siddharth sir will
Sir,
be-
I have few questions to ask from you, sir. A few questions to ask from you, sir.
Yes,
Can I ask
please.
it? Can I ask the question, sir?
Yeah, please go ahead, Siddharth.
Sir, will the act be applicable to digital data of corporates if that digital
Siddharth, your voice is not clear.
Sir, will the act be also applicable to any corporate data if that corporate data can identify an individual?
Yes, so any corporate who is collecting any individual's data, right?
Okay.
And that is actually used by some digital technology, digital platform. So the act is definitely going to apply.
Okay, sir. Is the provisions of the act won't apply when the data is provided voluntarily?
So there are certain situations. So that's why I have stated some of the situations. So when we are talking about whether that is a choice of a voluntarily providing the data or it is mandatory. So that is the test. So we have to apply the three tests as I said. So if the data principal has a right to say that, okay, I will not provide the data despite that you provide me the service, that becomes the voluntary status, right? In such case, still the data fiduciary has the obligation to use it only for the limited purposes and legal purposes. But yes, the whole life cycle of the consent management and the notice management that may get exempted.
Okay. Sir, is there any SDF significant data fiduciary which is notified by the government as on date?
Not yet, because as I said, the data protection board is still has to come. And second thing is that, but likely, what is going to likely, all the tech companies, social media platforms, banking and financial sector mostly, they may get fit into this significant data fiduciary.
Sir, if two persons are jointly collecting data, will they both be joint fiduciary and will they both be held liable?
So if jointly means what scenario can you explain? Under which scenario they are collecting jointly data?
Sir, sir, suppose there is an audit and if the audit is done by multiple partners jointly, so joint auditor's concept is there, concept of joint auditor. So in that case, both will be the joint data fiduciary. So in that case, will the act's obligation will be applicable to both of them?
No. See, audit is a different phenomenon. As I said, we are discussing about the statutory audit because statutory audit is a legal requirement. So what we are looking as a chartered accountant's perspective, that for that purposes, these provisions could be exempted because for certain government related businesses, they have exempted. So this is a legal requirement. So that for that purposes, it could be exempted. That is not an issue between you and me. That needs to be considered by the ICAI Council separately. So leave it apart. Now let us take the situation that there are two internal auditors. I'm taking that in that perspective. Let us say there are two different individual internal auditors. So each of them will be treated as an individual data processor here. Right? So everyone will be treated as a data processor.
Okay. So is there any penalty imposed on data processor in the act?
See, basic requirement is basic responsibility lies again on the data fiduciary. So any breach happens, that breach needs to be compensated or the penalized. It could be penalized through the data fiduciary, because he has to ensure that the data processor is having enough security safeguards. That was I was stating about. So when you are entering into the contract with the data processor, it is your responsibility to ensure that security safeguards. And that's why I said that you can talk about in your next session that how much large opportunities we are having. Even though review such contracts, even to evaluate such technical, compliance and security measures at the third party level or not. So he's going to do that. So it's a chartered accountant. So you can explore that area further. And as I said, yes, it's the liability lies on the data fiduciary. Only thing is that he can subsequently ask for the compensation from the data processor, but that is a different matter. That is not coming directly through these provisions of the Act.
Sir, even if no mala fide intention is established, can the penalty be imposed?
Penalty will not be in. See, there is a mechanism to enforce the penalty. So it requires again the forensic. That is one more opportunity, right? So what are the causes of the data leakage, and who is at the weakest link because of which the data is leaked? That needs to be investigated, inquired about. So the person is found to be responsible who has not adopted a proper security measures to protect the personal data, then he will be responsible. And if he being the data fiduciary, it will be the penalized. But if it is found that the data fiduciary has taken enough safeguards, despite of that the attack has happened, then there will be other way to look at it.
Okay. Sir, by means of verifiable consent in case of children's data, does it mean that we have to verify the identity details of the parent, that the parent is the parent of the child?
Of course, that is required. So you can say the KYC kind of things of the parents' data is very much essentially be required under the provisions of this Act. Yes, that is must.
Is the data protection officer obligation applicable only to the significant data fiduciary, sir?
Right now, the answer is yes. It is only mandatory. Mandatory. If you can see the mandate, it is mandatory for the SDF, significant data fiduciary. But even the organization who are handling a lot of personal data, let's take an example of an hospital. Some of the hospital may not be fall under the category of the significant data fiduciary. Some of the hotel sector may not fall under the category of data fiduciary. But still, they have to think about to avail the services like the DPO. Right? So mandatory for the SDF, but you can say required, even though not mandatory, it is required for all the major players in who are collecting a lots of data.
Thank you so much, sir. That was all the questions from my side. Thank you for such a wonderful deliberation and for enlightening us with all the knowledge and experience that you have, sir. It was great listening to you as always.
Thank you very much. Thank you, Siddharth, and take it ahead forward.
Thank you, sir.
Thank you.
Can I start, ma'am?
Yes, sir. You can start the session, sir.
Okay. Special thanks to the Professional Development Committee for this opportunity. Special thanks to the Chairman, sir, Abhay Chhajer, sir, Vice Chairman, Piyush Chhajer, sir, and my co-speaker and teacher, Uday Kulkarni, sir. Sir, it was great listening to you as always. Now, with this, I will start sharing my screen. Kindly confirm if the screen is visible. Please turn the sharing on for me. Is it visible, sir? Okay, so now we will cover safeguards and opportunities for chartered accountants. That what are the safeguards that we have to take when we are complying with the DPDP Act, and what are the opportunities that DPDP Act has given us? First of all, DPDP Act has given us immense opportunities because in this act there is no limit prescribed. Like in income tax, we have a limit. In GST, we have the limit that if the turnover crosses 20 lakhs in case of services, then you have to register for GST, or 40 lakhs in case of goods, then you have to register for GST. But in DPDP, there is no limit. There is only one thing that is written, that it applies to individual personal data. That it means any data by which digital personal data by which an individual can be identified is covered under the gamut of DPDP Act. So here, what we will see today, CA is dual mandate, that we have dual mandate, our obligations as a chartered accountant and our opportunities that we can monetize it. Then safeguards for CA firms, 4 safeguards for CA firms, the 4 core basic safeguards that we have to take in our office when we are dealing with digital personal data. Then penalty schedule and real life case studies. So that case studies will help us in understanding the whole object behind the act. Professional opportunities for CA, we will see DPIA, that is data protection impact assessment, as Uday sir has also mentioned in this presentation, that every significant data fiduciary is required to conduct data protection impact assessment. Then 30-day action plan, how we will organize our practice and how we will make ourselves adaptive to this DPDP Act, and key takes away and way forward. Now, what is an obligation as a data fiduciary? First obligation, sir has also explained, that issue privacy notices to client. We cannot collect personal data of the client, digital personal data of the client, without giving notice to the client and without obtaining consent from the client. Because even if we are collecting the data in physical form, the moment we scan it or the moment we take a picture of it, the data becomes digital personal data. And the moment the data becomes digital personal data, the provisions of the DPDP Act applies to us. So if we are collecting a data in paper format or in physical format, then that is non-digital personal data only till the time it is not scanned or taken a picture. But the moment we had scanned it or took a picture, it becomes digital personal data. So please take consent and give notice in those situations also. If you are about to digitize that data later, obtain explicit written consent. That silence amounts to acceptance is valid in Contract Act. It is not valid in DPDP Act. So obtain explicit written consent. What it means by explicit means there should be a clear written consent from the data principal before processing data. Encrypt all client data. That is, we must store the data by encryption method. Encryption method means we must use a code or we must use an indirect identifier. We should not we should not store our client data as it is, so that the name of the client and the details of the data is visible to everyone in the office. Sign contracts with all vendors. That is very important. Sir has also explained that we have to enter into contract with our data processors. Otherwise, there are huge penalty on us as a data fiduciary. So when we are collecting personal data and when we are sharing that personal data to the data processor, then we have to enter into contract with all those data processors. And that contract vetting and that contract drafting is a very big opportunity for us as a chartered accountant, because for every data processor, it will require a valid contract. And for that valid contract, there are many clauses that are to be incorporated in that data processor agreement contract, and that process agreement will be drafted by us, will be made by us. Report breaches within 72 hours. It is also an obligation on the data fiduciary that if any breach of personal data has happened, then we have to report immediately to the Data Protection Board and data principal that the breach has occurred, and within 72 hours, a detailed report is also given that explain the nature, timing, and extent of the breach and location of the breach, and what are the mitigating actions that are being taken by the data principal. So that report has to be submitted within 72 hours. Now, what are the opportunity for us as a strategic advisor? So the opportunities are DPO as a service of SMEs. Sir has explained that significant data fiduciary is required to appoint a data protection officer. Now, what is data protection officer? Data protection officer must be an individual in India, must be an individual resident in India. That is written in the Act. So we all are individual resident in India. So DPO is an opportunity for us that is applicable for every significant data fiduciaries, and even for those significant data fiduciaries or those data fiduciaries which are not significant data fiduciaries, they can also appoint a DPO-like person in their office to align their practices with the practices followed by significant data fiduciaries. So SMEs, all the small and medium entities, they can afford a virtual DPO. If they cannot afford a full-time DPO, then they can appoint a virtual DPO also. Then DPIA consulting and audits. What is DPIA consulting and audits? Data protection impact assessment. It is an obligation casted on the significant data fiduciary, and it is an annual obligation. What is data protection impact assessment? It assesses the risk to the right of data principal. Sir, I explained that data principal has 4 rights: Section 11, Section 12, Section 13, and Section 14. Right to access data, right to correction, erasure, right to grievance redressal, right to nominate. These are the 4 rights that have been explained of data principal. So this data protection impact assessment is about assessing the risk to the right of data principals. And audits. In the Act, there is a data Annual audit is also prescribed for significant data fiduciaries. Then consent manager setup or advisory. We are aware now that consent manager is an body corporate incorporated in India with a minimum net worth of 2 crore rupees and technical qualifications and technical capabilities as prescribed in the Act. So we chartered accountants can form a body corporate and register that body corporate with the Data Protection Board and can do the consent manager setup or advisory function. Then grievance redressal outsourcing, that is very important. In that, every data fiduciary is required to appoint a grievance redressal officer, a grievance redressal mechanism to address the complaints and address the grievances of data principals. Now, everyone cannot afford a full-time grievance redressal officer, so they can outsource that work to us as a virtual grievance redressal officer. Then DPDP compliance audits, that what we have to do, that how we can advise our clients to ensure their practices are DPDP compliant and audit of the same. Then first safeguard that we as a chartered accountant should know that, should take that, because we are collecting n number of personal data from n number of clients, is notice and valid consent. Don't collect any data without giving the notice and without obtaining a consent from the client, because if you do it without consent, then it is violation of the provisions of the Act. And what is the elements of consent? What is the attributes of consent? We have studied in Contract Act that consent must be free. Now, what is free? Free means consent should be free from mistake, misrepresentation, undue influence, or fraud. That means that the consent of the person should be free from all kind of influences, fraud, misrepresentation, and mistake. Then consent must be specific, that if we are collecting data for income tax return purposes, then that consent should be specific to income tax return purposes, and it should be clearly mentioned in the notice that we are collecting this data for income tax purposes. That's informed. What is meant by informed? Informed means that we have to inform the data principal that how we will use the data of the data principal, where we will store it, from whom we will share it. That is, if we are sharing the data with the data processor, then we have to specify in the notice that we may share this data with the data processor. Then unconditional, there should not be any condition attached to obtaining consent. That means there should not be a bundled consent. Data principal should have full right to accept or not accept the conditions specified in the notice. That is, no condition should be attached in the notice when obtaining consent. Then unambiguous. Unambiguous means there should be a clear affirmative action from the data principal. Silence on the part of data principal will not be considered as a consent. Unambiguous. There should be clear affirmative action from the data principal. A real life example we will see here. CA Ram files ITR for Mr. Sharma. Before accessing his AIS or TIS data, Ram must give a written privacy notice and get explicit documented consent for that specific assessment year. Now, what we are doing right now, we are accessing the client AIS or TIS data on the income tax portal because we are having the password of the client, and we are accessing that AIS or TIS whenever we want it. We cannot do it after the implementation of the DPDP Act, because as per DPDP Act, we have to obtain specific consent by giving a notice. So in the notice, we have to mention that we require your consent to access your AIS or TIS for that specific assessment year for this number of times. So that Ram must give a written privacy notice and get explicit documented consent for that specific assessment year that Ram will access AIS or TIS. The old engagement letter saying I authorize to represent me is insufficient under the DPDP Act. Many times we have an engagement letter from the client that I authorize you to represent me before all the authorities. This is not acceptable. If you are appearing in any case on behalf of your client, then you have to clearly specify that in which case and before which authority you are appearing, because consent needs to be specific, right? So this won't work now. Then purpose limitation and data minimization. Purpose limitation means, as sir has also explained, that if we are collecting data for ITR purposes, then we should use that data for ITR purposes only. If I am having the PAN number and identity details of the client, then I should not use that data for obtaining GST registration of the client without obtaining explicit consent from the client, because that violates the principle of purpose limitation. What it means by purpose limitation: data collected for one purpose cannot be used for another without fresh consent. Many of us, what are doing? We are providing advisory services, we are providing investment services to our clients, and we are not obtaining any kind of consent from the client. We are not giving any notice to the client. We are just using the data that is being given to the client by us for income tax or GST purpose, and we are using that income tax and GST purpose consent for doing this advisory services and doing these investment services also. So please stop that practice. Data collected for one purpose cannot be used for another without fresh consent. For every different purpose, there should be a consent. For every notice, there should be a consent. Then data minimization: collect only what is necessary. Stop the just-in practice immediately. Now, what it means, many times when the client asks us, sir, what data should I share for income tax purposes? We tell to the client, sir, whatever data you have with us regarding that assessment year, please share that. This is not acceptable now under the DPDP Act, because if you require client's particular document, then we must specify in the notice that we require particular document. We cannot just give in the notice that we require all the documents that belong to you for the particular assessment year. We need to specify which documents are relevant for us, and only those documents should be collected. The practice of over collection that we are doing for the year should now be completely stopped. So data minimization is the thing, that is the technical word for this. Collect only what is necessary. Stop the just in case practice immediately. Then violation: using the audit client data to cross-sell wealth management or insurance products without fresh consent is a direct DPDP Act violation. As I already explained you, that do not use the audit data to cross-sell wealth management or insurance products. Then technical and security measures that we have to take in our office: role-based access controls. Now, what happens in our office? The first year article has access to every system in the organization. First year article sits with everyone in the organization, and he has access to each and every system in the organization. So that should not happen. Article clerk access only their assigned clients. There should be a clear system that specific client should be assigned to the specific articles or employees, and only the article and only the clients that are assigned to a particular article or employee, that article or employee should have access to only to those assigned clients' data. He or she should not have access to data of all the clients, because the more access, the more probability of data leakage is there, data breach is there. So role-based access control is a technical measure. Article clerks access only their assigned clients, no blanket access to the full database. No one in the organization should have blanket access to the full database. If anyone is having any kind of access to any client data, then there should be a reason that why that person is accessing that client's data. There should be a connection with the access and the job responsibility. Then encrypt all client data, that I had explained earlier also, that don't save your client data by client name. Use indirect identifiers, anonymize that data, pseudonymize that data. That encrypt at rest, that when we are storing the data in our laptops and drives, we should encrypt the data with indirect identifiers or with codes or with hashed, so that the data is not identified to anybody in the organization. And in transit, emails and clouds, many times when we send an email, we do not password protect the attachment, and we, even if we password protect the attachment, we send the same password protected attachment with password to the receiver. And what happens if the email is sent to the wrong receiver? Then the receiver gets the document as well as password. So we have to make a practice that all email communication should be sent via password, and that password should not be sent simultaneously with the email. That password should be sent after sending the document, so that if by chance we had sent the document to the wrong recipient, then the password is not sent to the wrong recipient. So encrypt at rest when the data is storing is sitting at our laptops and drives. Then also we have to encrypt it, and when it is transit, when we are sharing it on email or cloud, then it should be encrypted. Password protect all attachments. That is very important. Multi-factor authentication, that means the executor and approver, or the executor and the authorizer should not be same. And in most of our office, we don't follow the principle of multi-factor authentication. We just collect data and we just give to anyone that we want in the organization, and there is no approver or authorization or issuer or any kind of rules in that. So mandatory multi-factor authentication for all cloud services, practice management systems, and email accounts. Even in email also, there should not be a single person that who is sending and receiving mails. There should be an issuer and authorizer, or issuer or approver mechanism, so that a check can be established in mail. Then breach response plan. what happens when a breach occurs, that suppose that if personal data of a client is sent accidentally to someone, like many times we see in a WhatsApp group that someone sends the data and then after a few hours the message is deleted. So with the DPDP Act, this is a clear data breach that you had shared the personal data of the client on to unauthorized users. So how you will contain that breach? So breach response plan is written protocol to respond to the breach. First is detect. That first step in the breach response is to detect the breach, that identify when the breach has happened. Then contain. Contain means remove the infected network from the systems, remove the infected system from the network so that the infection doesn't spread. Contain, then notify. Then we have to notify clients. First, we have to immediate notify to the clients and data protection board. Then we have to give a detailed report to the data protection board within 72 hours. So first is detect, first you identify the breach, then contain, then you prevent the breach from spreading, then you notify the clients and you notify data protection board, then a detailed report to the data protection board, and then the measures to remediate. So breach response plan is a very important secure safeguard for us as a chartered accountant. Then managing data processors, it is very important because as a chartered accountant, we are sharing the client's data on many data processors. If our vendor suffers a breach involving client data, we, the CA firm, are held liable. That is very important, that if a breach is caused by, suppose my client data is stored on Google Drive, and if a cyber attack happens on Google Drive and then the breach is caused by Google Drive, then me as a data fiduciary will be held liable. Although I can have a separate proceeding against the data processor for the loss damaged, but the data protection board won't question data processor. Data protection board will question only the data fiduciary, and as a data fiduciary, I will be liable for any penalty that is being imposed by the data protection board. So common data processors here are ClearText or Computex services. Like many of us use the doc scanner or Kagaz scanner for scanning documents. I love PDF for converting PDF files, merging PDF files. So these are the processors and they do use our data for their training purposes. Practice managing software as a services. If you are using any application on a pay per use basis or on a payment basis, then practice management software mandatory with every vendor before sharing any client data. Contract drafting is a very big opportunity that arises for all the chartered accountants. Then penalty schedule, it is one of the most important failure to implement reasonable security safeguards, breach of data. What is reasonable security safeguard? That if you are not able to implement multi-factor authentication, role-based access control, encryption, then you are liable for a maximum penalty that can be levied up to rupees 250 crores. Up to rupees 250 crores penalty for a single offense. Then another penalty, failure to notify breach to the data protection board or data principals. As has been already explained, we have to notify the breach to the data principal and the data protection board immediately, and a detailed report within 72 hours to the data protection board. So if we had failed to do so, then there is a penalty of up to rupees 200 crores. And if I had failed to take reasonable security safeguards and I also failed to notify data breach to the board or to the data principal, then the penalty will be up to 450 crores, 250 plus 200. These are separate penalties for separate offenses, separate mistakes. Then non-compliance with children data obligations, as we had already explained by sir, that non-compliance with children data, that for children we have to take verifiable parental consent. So suppose if verifiable parental consent is not taken, then penalty up to 200 crore rupees can be specified for failure to take reasonable security safeguard in respect of children data obligations, right? Then non-compliance by significant data fiduciaries. As significant data fiduciaries, some responsibilities are being assigned to the significant data fiduciaries, like data protection impact assessment, data audit, data appointment of data protection officer, and so if any such kind of compliance that is to be done by significant data fiduciary is not done by significant data fiduciary, then a penalty up to rupees 150 crore can be levied by the data protection board on the significant data fiduciaries. As of now, no one has been prescribed as a significant data fiduciary by the government, but we are very confident that many of the major e-commerce entities, major social media intermediaries, and major banks and NBFCs will be there. Breach of any other provision of the act or rules, if there is any mistake which is not specified in the previous 4 mistakes that we had studied, then there is a residual penalty of up to rupees 50 crores. So we have studied that 5 major penalties are there on the data fiduciaries. First is failure to implement reasonable security safeguards. In that, up to 250 crores penalty can be imposed. Failure to notify breach to the data protection board or data principal, up to rupees 200 crores can be imposed. For non-compliance with children data, up to rupees 200 crores, and additional obligations of significant data fiduciaries up to 150 crores, and residual penalty of up to 50 crores. And if the data principal is making frivolous complaints, vexatious complaints, if the data principal is not providing proper data, accurate data, then a penalty of up to rupees 10,000 is there on the data principal also. Then what the safeguards violations every CA firm must avoid? Audit data cross sale, that CA Mehta uses statutory audit to pitch wealth management products to the client promoters without fresh consent. So here the consent was from statutory audit, but that was used for wealth management. So here a penalty can be imposed under the residual provisions up to rupees 50 crores because there was a consent was the specific purpose was not followed. Consent obtained for one purpose was used for another purpose. Vendor data breach. A firm stores 500 clients on Google Drive with no signed DPA. Cyber breach exposes the data publicly. So if there is a cyber breach on the processor also, then a penalty up to rupees 250 crores for failure to take reasonable security safeguards can be imposed on the data fiduciary. So bulk SMS marketing traps. Here Ravi collects phone numbers during ITR filing, then sends 300 plus clients a bulk SMS marketing a fixed deposit product. So it is a violation of section 6, that is consent, that repurposing without consent, that again he is repurposing the data used for ITR filing for marketing a fixed deposit purpose. Then opportunities for a chartered accountant data protection officer as a services. I had already explained that every significant data fiduciary is required to appoint a data protection officer, and those significant data fiduciaries who don't have the budget to appoint a full-time data protection officer, they can appoint a virtual DPO also. So why we as a CAs are perfect for this role? Trusted advisor, because we are the trusted advisor of our client, and our client will appoint as a DPO, data protection officer. Audit expertise, data protection impact assessment, mirror internal control testing, because when we as a data protection officer, then we have to ensure that the data protection impact assessment is compliant and in the best interest of the entity. So that internal control testing CAs are best to do. Regulatory listening, CAs are very great in understanding law. So that's why data protection officer is a very big opportunity for every chartered accountant who is having a client who is a significant data fiduciary. And even those clients who are not significant data fiduciary, there will be many big clients who will want to adapt their practices to the standard that is being set by a company which has appointed a DPO. And 63 million MSMEs need DPO services but cannot afford full-time hire. So those clients which cannot afford a full-time DPO, for them virtual DPO is a big opportunity for chartered accountants, and fee range can be 8 to 10 lakh per annum for a virtual. It is a very big opportunity for all the chartered accountants, we as a chartered accountants. DPO as a service, then data protection, impact assessment, consulting, and data audit. Now, we had already explained that the significant data fiduciaries must conduct a data protection impact assessment annually. Annually, they have to do the data protection impact assessment. That means each year from the date they are notified as a significant data fiduciary. Now, what does DPIA do? DPIA is basically assessing the risk to the rights of data principals. So what are the steps in the DPIA consulting? Data flow mapping. We have to flow map how the data is collected, then processed, then used, then stored, then retrieved, and then deleted. There are 6 stages in the data life cycle. First is how the data is collected, then how it is processed, then how it is used, then how it is stored, then how we can retrieve that data for further use, and how we can delete that. So this is the 6-step process. Risk identification, then the DPIA, we have to identify the risk, that what are the privacy risk, the concern gaps and vulnerabilities in the data life cycle. We have to identify those gaps and vulnerabilities, then mitigation strategy. Then we have to, in the DPIA, we have to recommend actionable controls, that how we can mitigate this risk, how we can reduce this risk to an acceptably low level, and DPIA report. Then after reducing the risk, we have to make a report to the formal report for management board and data protection board, that we have to place a report before the board. Like an audit report, qualifications of data auditor are not yet prescribed, but we as a chartered accountant are perfectly positioned as the default choice if we have the requisite certifications like DPCAC or any further certificate that can be notified by the ministry. So we must adapt ourselves to the DPDP practices so that we can be considered as a suitable candidate for data auditor. Then 6-step DPIA methodology, how we do the DPIA data protection impact assessment. Scope and map processing. First, we have to define the purpose, data categories, and the full data flow across the life cycle. We have to first determine how we will scope our impact assessment, and we have to map processing which different activities. We will define the purpose of the processing, data categories, and how the full data flow across the life cycle. The necessity and proportionality, we have to see whether the collected data is necessary for collecting and whether the data is not over collected, that the collection of data is proportionate to the requirement. Then stakeholder consultation, we have to engage data principals, processors, and the data protection officers to surface real world concerns, because when there is a stakeholder consultation, when the data principal, data processors all are involved, then the outcome of the DPIA will be best. Identify and assess risk, as already discussed, that we have to rate likelihood and impact of privacy harms, consent gaps, and breach exposures. We have to identify and assess how much these gaps are impactful and vulnerable. Mitigation and controls, then we have to mitigate the risk by encryption, role-based access controls, multi-factor authentications, and data processing agreements. Report sign-off and reviews, as already explained. Then we have to document findings and give a report to the board. So these are the 6 steps. First, we have to scope and map the process full. Then necessity and proportionate, whether the data collected is proportionate and necessitated. Stakeholder consultation. Then we have to identify and assess the risk that are associated with it, mitigate the risk, and report sign-off. Then consent manager is a very big opportunity. A single platforms for individuals to manage consent across all entities. I already explained it earlier. Direct its requirement is set up as an Indian company registered with the board. Net worth of the company should be greater than 2 crores. Consent manager is a platform for the data principals to give, manage, and withdraw their consent in a seamless and exchanging platform. Assurance as audit of consent manager platform is also a very big opportunity. Advisory, providing advisories to the consent manager platforms is also a very big opportunity for the chartered accountants. And the opportunity 4, which is I think the biggest opportunity of all this, is the grievance redressal, because every data fiduciary is required to have a grievance redressal mechanism through which the concerns of the data principal can be addressed and through which the data principal grievances can be solved. So every data fiduciary must have a grievance mechanism regardless of size. So even a small vendor is liable to have a grievance redressal mechanism. And what in grievance redressal, we have to acknowledge complaints preferably within 48 hours that the complaint has been received. Resolved within 90 days. Rule 14 says that all the grievances of the data principal must be resolved within 90 days. 63+ million MSMEs cannot manage this in-house because grievance redressal full-time they cannot afford. So they will appoint a virtual grievance redressal officer. Outsourcing to CA firm recurring revenue, because it is applicable to all the data fiduciaries, and every data fiduciary is required to have a grievance redressal mechanism. Established client relationship, plus we have trust with our clients. That's why we are the best person to have grievance redressal officer. Then there are some questions for us to test our knowledge. Under the DPDP Act, the requirement that consent be a free, specific, informed, unconditional, and unambiguous affirmative action is codified as Section 5. Section 5 talks about notice, so Section 5 is not the answer. Section 6 talks about consent, so Section 6 can be the answer. Section 8 talks about obligations of data fiduciary, so that is not the answer. And Section 10 talks about rights of data principal. So the correct answer is Section 6, because Section 6 relates to consent. So consent must be free, specific, informed, unconditional, and unambiguous. CA Mehta uses statutory audit data to pitch wealth management products to the same client promoters without fresh consent. Here the fresh consent is not obtained. The previous consent is used for pitching this also. So here purpose limitation, Section 6, data localization rule, Section 13, grievance redressal, or Section 10, SDF obligations. Here purpose limitation, Section 6 is not complied. So the correct answer is breach of Section 6. Under the schedule of the DPDP Act, the maximum penalty for failure to implement reasonable security safeguards is 50 crores is the residual penalty. 150 crore is the penalty for significant data fiduciary, additional obligations of significant data fiduciary. 200 crores is the penalty for failure to give intimation of breach and for obligations in relation to children data. So 250 crores is the answer of maximum penalty for failure to implement reasonable security safeguards, breach of data. Then under Rule 7 of the DPDP rules, a personal data breach must be reported to the Data Protection Board of India. We had studied this n number of times, that any breach must be reported to the Data Protection Board of India within 72 hours? The answer is any breach must be reported to the Data Protection Board of India within 72 hours. Immediately to the data principal and to the Data Protection Board, and then a detailed report to the Data Protection Board within a period of 72 hours. That is very important for all of us to remember. A CA firm stores client Aadhaar or PAN data with a cloud vendor without a signed data processing agreement. Here, what has happened that CA firm has stored client or Aadhaar PAN with a cloud vendor without a signed data processing agreement. There was no signed data processing agreement. If the vendor suffer a breach under section 2(8), the primary liability rests with the, we have studied that if we are sharing data with the data processor, then the data fiduciary will only be liable in the act, and the Data Protection Board will only levy penalty on the data fiduciary. Although the data fiduciary has the right to sue separately the data processor for damages, but here the primary liability as per the section 8, that is obligations of data fiduciary, will rest with the CA firm, that is data fiduciary, because in the act there is no any kind of penalty levied on the data processor, because he is not doing anything on his own. Whatever he is doing is as per the instructions and as per the directions given by the data fiduciary. Data processor is not doing anything on its own. That's why data processor is not penalized for anything in the act. Role-based access control, encryption at rest or in transit, and mandatory multi-factor authentication fall under which safeguard? These are the role-based access control, encryption at rest or in transit, and mandatory multi-factor authentication fall under which safeguard? The options are notice and valid concern. These are not related to notice and valid concern. Purpose limitation and minimization. These are also not related to purpose limitation and minimization. Technical and security measures. Yes, role-based access controls, encryption, and multi-factor authentication fall under technical and security measures. So this will be covered in technical and security measures safeguards, and managing data processors is also not covered here in role-based access control. CA Ravi reuses phone numbers collected during RTA filing to send a bulk marketing SMS. Against there is a purpose creep. Consent obtained for one purpose is used for another purpose. So do nothing. Phone numbers are in personal data. No phone numbers are personal data. So the option A is not correct. Obtain fresh, explicit, opt-in marketing consent. Yes, if he is using ITR filing data for marketing purposes, then he has to obtain a fresh consent. Report the matter to the Data Protection Board within 72 hours. Here, no breach is made, hence this is not applicable. Register the firm as a consent manager. This is irrelevant to the above scenario. So the correct answer is B, obtain fresh, explicit opt-in marketing consent. What it means by you have to obtain a fresh, explicit opt-in marketing consent, that a fresh consent should be obtained. Under section 10 of the data protection, impact assessment is mandatory. I had already explained this, that data protection impact assessment and data audit is mandatory for every significant data fiduciaries, and that is an annual requirement. That is from the date the significant data fiduciary is notified as a significant data fiduciary, that is an annual requirement that is to be done every year. So here the options are every data fiduciary. No, data protection impact assessment is not mandatory for every data fiduciary. Only grievance redressal mechanism is mandatory for every data fiduciary. Every data processor, no, not applies to data processor. Significant data fiduciaries and only government bodies. So the correct answer is C, significant data fiduciaries. Then is the 6-step DPIA methodology testing the lawful basis, validity of consent, and applying data minimization correspond to scope and map processing. Step 2, necessity and proportionality. Step 4, identify and assess risk. And step 6, report, sign off, and review. So in the data protection impact assessment methodology, testing the lawful basis and validity of consent and applying data minimization is corresponding to step 2, that is necessity and proportionality. What is meant by necessity and proportionality? Necessity means that the data is required for the defined user objective, and proportionate, and the collection of data is proportionate to the information required for achieving that objective. So if there is no over collection of data, so it is a data minimization. The principle of data minimization directly relates to the proportionality principle specified in the Act. Then under Rule 14 of the DPDP rules, a data fiduciary offering grievance redressal, including a CA firm providing this as an outsourced service, must resolve a grievance within. We had studied that grievance should be acknowledged within 48 hours preferably, and any grievance that is raised by data principal regarding the 4 rights that the data principal has, that is right to access, right to correction, erasure, right to grievance redressal, and right to nominate. These are the 4 rights that are being given to the data principal from section 11 to section 14. So the grievance must be resolved within a period of, option is 30 days, 60 days, 90 days, and 120 days. The answer is 90 days. Grievance should be resolved within a period of 90 days. That is very important for all of us to remember, that every grievance that is being raised by the data principal to the data fiduciary must be resolved within a period of 90 days. Then what is our action plan, your 30-day action plan, that we as a chartered accountant are now on this day and we don't have any practice which is commensurate with the DPDP Act requirements. So what is the first thing that we do? Week 1, map all data and update engagement letter with privacy notices. First is the map all data. Whatever data is lying in our office, first map that data, that whether we had obtained, given notice and obtained consent for each and every data that is lying with us. If not, then we have to update our engagement letters with privacy notices, and that privacy notices should not be hidden inside the engagement letters. That privacy notices should be prominently displayed along with engagement letters. That means a separate document should be made for the privacy notice, and for all the data that is being resided in our office, we have to see whether we have given the notice and have obtained the consent. If we had not given the notice and had not obtained the consent, then we have to give the notice and obtain consent for all further processing, because the moment the DPDP Act becomes implemented from 13th May 2027, all these provisions will be fully applicable, and then we cannot say that we had collected this data before. Even if we had collected the data before the implementation of the DPDP Act, then before the applicability of the DPDP Act becomes operational, we have to give our clients notice explaining what are their rights as a data principal and what data we had collected, and if we require further processing, then we have to obtain a fresh consent from the client by giving a notice. Then execute written data protection agreements, data processing agreements with all vendors, ClearText, Google Drive, etc. Now also we are storing our data with a number of processors. Even we are giving the clients data to the AI tools like ChatGPT, Claude, Gemini, and many of us are even not redacting that data. So whenever we are sharing any data with the client's data with the AI tools or with the ClearText Google Drive, then we should mention in the privacy notice given to the client that we may store your data with this Google Drive, etc., and we may store your data with ClearText, and we may share your data with AI LLM tools like ChatGPT, Claude in redacted format, and we should obtain a specific consent from our client for that purpose. Week 2, implement role-based access control and enable multi-factor authentication on all systems. This is also very important. Almost all the systems that we have in our office, every person in the organization has access to every system. So role-based access control is that whatever access a person is having in the office should be commensurate with the role that the person is being assigned, and enable multi-factor authentication on all systems. That means on all system, multi-factor authentication should be there. That means a issuer approver or a issuer authorizer concept should be there, and it should not be a blanket authority to anyone in the organization to do both the functions. Then week 2, encrypt client data at rest and in transit, password protect all emails. It is very important that the client data is stored in our system, it should be encrypted. By encryption, it can be pseudonymization or anonymization. Pseudonymization means that replace direct identifiers with indirect identifiers, and anonymization means altering data so that it cannot be identified. But pseudonymization is reversible, anonymization is not reversible. So we have to do anonymization technique as applicable to us. So encrypt client data at rest and in transit, password protect all emails. That is also very important. Then draft a data breach response protocol and appoint a grievance officer. That is very important. Draft a data breach response protocol. Now, what will we do if a breach occurs? So we have to draft a data breach response protocol in our office, and we have to test that draft data breach response protocol with the practices followed in our office, that how we will be able to notify data principals or data protection board if any breach happens in our office, and what are the methods and what are the technologies being deployed in our office through which we can notify that personal data breach to the data principal and also to the data protection board, and appoint a grievance officer. As we have said, a grievance officer is mandatory for every data fiduciary, and grievance officer is there to address the grievances of the data principal. So we should have a mechanism that what happens if a data principal raises a complaint or raises a grievance, then how our system is able to address it. Then week 4, their monetization opportunity, identify top clients to pitch for DPO or data protection impact assessment services revenue opportunity. We all are aware that data protection officer and data protection impact assessment is a mandatory obligation on the significant data fiduciaries. And even those organizations who are not appointed as a significant data fiduciaries, they can have a person similar to the data protection officer and they can do the data protection impact assessment to align their practices with the industry standards. So we have to identify the top 5 clients to whom we can pitch for DPO or DPIA services, and it is a recurring revenue opportunity. Every year it is an opportunity for us. Then the 3 key takeaways from our session today is our firm is a data fiduciary. We are a data fiduciary because we are collecting a number of data from our clients and we are deciding the means and purpose of processing personal data. That is very important. In the definition, it is explicitly said that the person who decides the means and purpose of processing personal data is the data fiduciary. So when we are collecting the data from our client, we are the person who are deciding the means and purpose of processing personal data. So we are a data fiduciary in such case. Your firm is a CA firm is a data fiduciary. Update engagement letters and security practices. Today, we are a data fiduciary, and as a data fiduciary, we are liable to severe penalties that are being imposed by the Data Protection Board that are being specified in the Act. So we have to update our practices so that we don't fall into any of the penalties. Non-compliance penalty up to 250 crores. If we fail to comply with any of the obligations specified, then there is a penalty up to rupees 250 crores for a single offense. And then there are 4-5 offenses. So for different offenses, there are different penalties. So for each offense, there is a penalty. So that penalty is cumulative and not. So for each offense, we can have a penalty of up to 250 or 200 or 150. So a huge penalty can be imposed on us. This is statutory obligation, not optional. The DPDPA creates new revenue streams. What are the revenue streams that the DPDPA covered for us? Data protection officer, that is applicable to every significant data fiduciary, and even a person who is not a significant data fiduciary, they can appoint a DPO to align with the industry best practices. Data protection impact assessment applicable to every significant data fiduciary on a recurring scale every year. And those who are not significant data fiduciary, they can also, to align their practices with the industry standards, do a data protection impact assessment. Consent manager, an entity with a minimum net worth of rupees 2 crores, must be registered as a body corporate and be registered with the Data Protection Board. Consent manager, an interoperable platform to give, manage, and withdraw consent across multiple data fiduciaries. This is the consent manager framework, and there will be many entities who will onboard this platform as a consent manager, because every person won't have the means to have in-house consent and notice mechanism. So they will onboard a consent manager who will manage the consent on their behalf. And grievance services, these are mandatory for every data fiduciaries. So every data fiduciary is required to have a grievance redressal mechanism, and it is a very big opportunity for chartered accountant that almost every client is required to have a grievance redressal mechanism. And for grievance redressal mechanism, there is a grievance redressal officer or a person who can handle the grievances of the data principal. So this was all from my side. I am open for the questions, if any.
So shall we go ahead with the questions?
Yes, ma'am.
Okay. So the first question is, can chartered accountants develop specialized data privacy compliance practices similar to GST, insolvency, ESG, or forensic audit services for this DPDP Act?
Yes, chartered accountant can develop services, but as of now, the qualifications of data auditor is not prescribed. So we cannot see that whether the chartered accountant is fitted for the role of data auditor as of now. But for other services like data protection impact assessment, data protection consulting, for vetting of data processor agreements, and for drafting of policies, and for all the incidental matters, pre-chartered accountants are best suited for all these matters. Any more question, ma'am?
Next is, how can chartered accountants assist boards and audit committees in strengthening data governance and oversight?
So first is we can help the companies in data protection impact assessment, that where they stand today, because until and unless they don't do the assessment, they will not be able to determine where they stand. And on the basis of data protection impact assessment, whatever deficiencies that we had found, then we can implement the mechanisms that we had studied today, like role by access control, multi-factor authentication, encryption, notice and consent, and through which we can improve the practices of our client.
Okay. Next is, what role do internal controls and risk management play in ensuring data protection compliance?
Ma'am, internal control plays a very important role because if the firm is having internal controls like encryption, role-based access control, multi-factor authentication, contract with the data processors, then there will be very less chances of a data breach from the company side and firm side. So if the internal controls and the best practices are followed by the organization, then there will be a very less chance of penalty, and we can, as chartered accountant, guide the company in doing so.
Okay. What practical safeguards should organization implement to ensure compliance with the DPDP Act?
Practical safeguards, sir, we had talked about in the session also that we had to do the encryption of data at rest and data in transit. Then we have to do multi-factor authentication that the single person should not have the issuing and approving rights in the organization. Then role-based access control that every person in the organization should have access limited to his role, and then process then contracts with the data processors, and these are and notice and consent. These are the safeguards that we have to take to align our practices with the DPDP.
Siddharth,
Yeah.
may I come to for this answer?
Yes, sir, sure.
See, in case of this data protection, data governance is a basic thing. In the data governance, data classification, data minimization, and when we are talking about data governance, the policies, procedures, all those stuff comes. But practically, how to implement that? That is a key question. And there comes the data inventorization and data minimization. Data minimization is related to the data classification. And there, when we are talking about the role-based access, the data minimization plays a greater role in the role-based access. And there, what data to which kind of a role and how that will be made available. And what is the use of that data by that particular role of an user. So all that things needs to be mapped in a very well manner. First in the policy, second in the procedure, third actually with the use of the technology. So it's not only a concept where you can go with a documentary things, you have to show the implementation of that, because any breach with any kind of an technological failure will attract the penalty, and that needs to be investigated and that needs to be trailed out. So technology along with the proper aligned policy and procedure is must to ensure the compliance of the provisions.
Right. So these were the all questions that I've received from the participants. Thank you so much for your valuable time for the webinar, sir.
Thank you, ma'am. Thank you so
Udit
much.
sir and Siddharth sir.
Thank
Thank you
you.
so
Thank
much,
you.
sir.
Thank you very much. Thank you, Siddharth.
Thank you, sir. Thank you.
Tech support, you can go offline now.